Hi everyone, I'm Neama Rahmani, real lawyer, former prosecutor, giving my analysis of the Lincoln Lawyer Season 2, Part 2.
Dear Mr. Grant, this letter is to inform you that you're a target of an FBI investigation into construction fraud in Southern California. Receipt of this letter puts you on notice to not destroy any documents related to your business. We'll make every effort to meet with you to discuss this matter. Signed, Felix Vasquez, Special Agent.
What's the date on the letter?
January 18th.
What's the date on the email Mitchell Bondurant sent to Alex Grant?
January 10th.
Okay, so Mitchell Bondurant threatens to expose Alex Grant to the feds. And 8 days later, Alex Grant gets a letter from the FBI saying he's a target of an investigation.
Well?
And a week after that, Mitchell Bondurant is brutally murdered.
Objection. Is there an actual question here?
Sustained.
Now, given these alarming facts, Detective, do you still think your failure to consider Alex Grant as a suspect was reasonable?
As I said before, we considered everyone.
Not for very long, apparently. You arrested Lisa Trammell the same day.
Because that's who the evidence pointed to. The motive was clear.
Motive? Don't these documents show that Alex Grant had a crystal clear motive to kill Mitchell Bondurant?
Objection.
I
Argumentative.
guess that's one way to interpret it, yeah.
Overruled.
You had tunnel vision, didn't you, Detective? You found an easy suspect, and you weren't gonna let anything distract you from that path. Evidence?
No,
fact.
I did not know about the target letter. And if I had a...
If you had what? Would you have done things differently?
I stand by our investigation and where it led. We got the right person.
Did you? No further questions, Your Honor.
This is very effective cross-examination by the defense attorney here of the case agent. So the case agent is the one who is primarily charged with handling the investigation. And it starts with a target letter. So the feds, but not state officials, they will send a letter to the target or subject of their investigation, sometimes putting them on notice. So that tells them not to destroy evidence. And here, a target letter was sent, but it also points to potentially another person who had motive to kill the victim. And why is this important? Defense lawyers love to argue that the investigating officers or agents in the case, they rushed to judgment. They had a sloppy investigation. They didn't rule out other subjects. That creates a reasonable doubt, and this is defense lawyering 101. So if you are the investigating officer on the case, you have to be prepared for this line of questioning. It's very common, and this witness did a poor job of addressing it.
What your conclusions were?
The blood on the glove is a definitive match to the murder victim, Mitchell Bondurant.
Now, turning to the blood sample on the hammer, I'd like you to walk us through your comparison of the
Your
two.
Honor, to save us from another lengthy explanation of DNA, we'll stipulate that the blood on the hammer is a match to the victim.
May we approach?
You trust me, right? Whatever I need to do.
Your Honor, it's clear what Mr. Holler's little game is here.
What game? I'm agreeing with you.
He's trying to prevent me from presenting my evidence in a methodical and convincing manner.
So I'm denying your theatrics. I'm sorry. Is that illegal?
I am all for moving things along, Mr. Holler. But I don't want this thrown back in my lap on appeal.
Your Honor, my client was framed. That's been our defense all along. Now, I have no doubt that this hammer was a murder weapon because the killer planted it there, just like the gloves.
And your client is on board with all of this?
Yes.
Fine. The court accepts the stipulation. I will instruct the jury after lunch.
So a stipulation is when the parties agree that some fact is proven. And here, that fact is that the blood on this hammer is the victim's blood. So normally when you're dealing with key pieces of evidence, the prosecution doesn't want it to be stipulated away. They want to show that murder weapon to the jurors. And usually, the court doesn't have to accept the stipulation, but in this case, the judge wants to move things along. Apparently there was some testimony before about DNA, and sometimes these experts can go on for a long time. So when the defense said, hey, we're gonna stipulate to this, even though the prosecution didn't agree, the court accepted the stipulation, which means the jurors are gonna be read an instruction that that blood belongs to the victim.
Why did your husband leave you?
I guess he couldn't handle the responsibility.
Of your restaurant?
Among other things, yes.
So it wasn't because you were difficult to get along with?
I was difficult? That's a good one.
Miss Trammell, please answer the question.
Look, I don't know why he left. You'd have to ask him.
Okay. Maybe I will. Where's your husband now?
Couldn't tell you.
You don't know?
On a beach in Mexico, last I heard.
Well, he had to get as far away from you as possible, huh?
Objection.
That piece of shit was lucky to have me. Order!
Will not tolerate outbursts in my courtroom.
We can all see why he left, can't we?
Objection.
Withdrawn. Nothing further.
Redirect.
Miss Trammell, one question. Did you kill Mitchell Bondurant?
No, I didn't.
Nothing further.
When you're a criminal defense attorney and you put your client on the stand, the entire case is going to come down to his or her testimony. The jurors will throw everything else out and focus on the credibility and the likability of the defendant. So it's a really risky move. If the defendant testifies well, that may result in an acquittal. But if he or she testifies poorly, they'll get convicted. So what you don't want is a witness who loses his or her cool during cross-examination. People that are honest, they tend not to react like that. Jurors don't like emotional outbursts, and judges don't either. So I'm sure the defense lawyer wasn't happy with this type of response when you're dealing with questions of what happened to your ex-husband. It's normal. People leave, divorces can get nasty. I think she should have answered it in a more calm and cool manner.
Mr. Holler, you know damn well it is your duty to inform the court if you have any indication that a witness might be even thinking about pleading the fifth.
Your Honor, I had no way to know what this witness would do on the
You
stand.
gotta be fucking kidding.
Miss Freeman, you will conduct yourself with professionalism when you are in my chambers and in my court. Is that understood?
I apologize, Your Honor.
She's got a fucking point, counsel.
Mr. Grant agreed to testify at the motion to quash. He didn't plead the fifth, and I had no way to know he'd do it now.
No. He planted this story in the jury's minds, and now that his witnesses pled the fifth, I can't even cross-examine him. Your Honor, he has manipulated the entire trial with this stunt.
Mr. Holler, if I find any evidence that this was premeditated, I will bring you up on disciplinary charges with the bar. As it is, I am striking the witness's testimony, all of it.
Your Honor, there's no unringing this bell.
I understand, Miss Freeman. But unless you have proof that Mr. Holler was planning this from the start, I am not granting a mistrial. I will instruct the jury that they may not infer guilt for Mr. Grant's refusal to answer questions.
You still had a problem, though.
Everyone has the right to remain silent, not just the defendant in court, but witnesses on the stand. So, if a witness is not going to testify during cross-examination, then they shouldn't be allowed to testify during direct. So what happened here was the defense put on a witness, he testified, and when the prosecution got up to cross-examine that witness, the witness said, I'm going to remain silent. So in this case, the testimony should be stricken entirely, which means that it's going to be left out. The problem is, though, the jury has already heard it. So even though the judge is going to instruct them not to regard it at all and to put it out of their minds or disregard it, you can't unring the bell or put the toothpaste back in the tube. So oftentimes what lawyers will want to do is ask for a mistrial, have the case start all over so you can have a new jury hear the case that hasn't heard that testimony. But the judge says, I'm not going to do it. We're so far along this case that if you ask for a mistrial, I won't grant it. So now the question is, did this defense lawyer try to do something sneaky, try to get this evidence in, knowing it wouldn't be subject to cross-examination, or was this truly a surprise? Thanks for watching, everyone. Make sure to like, follow, and ring the bell for notifications, and catch us back here for Season 3 of The Lincoln Lawyer, analyzed by a real lawyer.